Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss legal victories and challenges to your fundamental freedom and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, founder and chairman of Liberty Counsel, explains the latest legal issues all across this country. In the courtrooms of America, Liberty Counsel is winning the battle for your constitutional freedom.
Liberty Counsel files an amicus brief in California's Proposition 8 marriage case. I'm Matt Barber, Vice President of Liberty Counsel Action, and joining me on the phone today is Steve Cramption, General Counsel and Vice President with Liberty Counsel. Steve, how are you doing today from Tupelo, Mississippi?
Matt, we're doing great. It's good to be with you. Thanks for having me.
Excellent. What is the latest in the Proposition 8 case? The Supreme Court is going to be looking at this thing real soon, am I right?
That's exactly right. Briefs are being filed as we speak, and the case is actually even set for oral argument on March 26th. It's going to be one of those red-letter days in Washington, and the lines will be long to get in to hear parts of the argument.
Absolutely. Now, what are the theories that Liberty Counsel is putting forward, the arguments that we're putting forward in our amicus brief?
Well, let me set it up here too, Matt, if I may, and
Sure.
kind of put that in context. As you will recall, and many of our listeners will remember, this case has sort of a tortured history because back in the year 2000, California, like many other states across the country, passed its own, what they call mini DOMA, Defense of Marriage Act. This was just a statute that defined marriage as being between one man and one woman only. But the state Supreme Court found that statute unconstitutional under the state constitutional version of the Equal Protection Clause. Then the people went back. Remember, this is this liberal state of California.
Sure.
And put together Prop 8, as we call it here, and passed another one, making it a constitutional amendment to the California Constitution. Then the homosexuals got together, challenged that one in federal court, and the federal court declared it unconstitutional under the federal Equal Protection Clause. That's the case that is now up before the U.S. Supreme Court. So in addition to the enormously weighty issues concerning whether marriage really ought to be limited to one man and one woman, as it always has been historically, there is the weighty issue of states' rights and the right of the people to amend their own state constitution. So this case just kind of snowballs in importance. One of the critical elements of the Ninth Circuit's opinion, which ironically enough, you know, the Ninth Circuit long noted for being so far left and wanting to trailblaze for liberals, actually engaged in what they called some judicial restraint. And they decided this case on what they hold was the narrowest ground, namely that you cannot, once homosexuals have been granted rights, as they were by the courts in California, to take those rights away from them requires a little different analysis. And so what the California arguments were here, and the Ninth Circuit kind of latched onto, was you can't do this in the same way that you can't do what they did or tried to do in Colorado back with the Romer against Evans case, which was decided in 2003. That's the argument that Liberty Counsel has focused on in our amicus brief. It is really the heart of the reasoning of the Ninth Circuit Court of Appeals here that ends up striking Prop 8. And what that basically does is it says whatever you may or may not can do by virtue of state constitutional amendment and the people's initiative and referendum system, you cannot kind of single out one group of people and harm them in a specific sort of manner. So it's almost like a little sleight of hand here. What the court at the Ninth Circuit did is say, well, even though it was the California Supreme Court that nullified the first mini-DOMA law. Once that right was granted to homosexuals to marry, and there were like over 18,000 that actually did marry during this little window of time, you can't now take it away by virtue of another state constitutional amendment. And so, as I say, all the argument revolves around trying to win over. In essence, here's what we're doing. We're head counting at the Supreme Court. As you know, there are 4 very hardcore, staunch liberal justices, 4 hardcore conservative justices, and then there's Anthony Kennedy. Anthony Kennedy authored the opinion in the Romer case, and much of the briefing at the Supreme Court now revolves around trying to persuade that all-important swing vote, Justice Kennedy.
There is a possibility that this case will not be the panacea that the left is hoping for, that will just basically open the floodgates for so-called same-sex marriage across America. This case could be very narrowly decided and very narrowly applied in the state of California in just a couple counties. Is that correct?
Yes, and then there's another twist here, Matt. So this thing, with its technical sort of tentacles, if you will, has all kinds of potential for the Supreme Court not to do what the homosexual lobby really hopes it will do and kind of knock open the entirety of the same-sex right to marriage. And so, among other things, you've got the fact that it's not the entire state of California that's involved in this litigation. It could indeed be limited to only the counties in which this particular case arose, because that's only the only place where the particular plaintiffs came from. And of course, the general rule in litigation is the court only decides the dispute between the parties. If you don't have parties from every county, then their ruling doesn't affect every county. Now, as a practical matter, it would probably become a moot point over time, because they then, once this case was decided in favor of the homosexual couples in those counties, others in other counties would come in and say, hey, you got to do the same thing that they did over there. But then there's another twist. The Supreme Court has raised an issue regarding the right of the defense counsel defending the traditional marriage view to actually come in and defend.
Standing, sure.
Exactly, the standing argument, because our so-called Republican Governor Schwarzenegger refused to defend the law, as did the state attorney general. So you had no traditional defense counsel. And instead, what the courts did is allowed the proponents of Prop 22, or I'm sorry, Prop 8 in this case, to come in and offer argument. So, as I say, it's got all kinds of technical layers before you actually get to the heart of the merits in this case.
Well, the bottom line is that this is a metaphor for the ongoing battle for marriage. There are those who want to radically deconstruct the institution of marriage, to say that it is not what it has always been, the union of a male, female, the uniting of a man and woman for the purposes of procreation. And then there are those of us who say, look, marriage is a fundamental cornerstone of any and every healthy society. And if we start radically redefining and deconstructing marriage, then a society suffers for it. We just have about 30 seconds here, but your closing thoughts, Steve.
Matt, it's what you said there at the end. We've got to keep our eye on the crux of this issue, and that is marriage. I mean, I'd love to talk a little more about, we say often it's the building block, it's the fundamental cornerstone of society. I think it behooves us to really expound on that and drive home to the American people how critical this really is. Society itself is on the verge of total collapse if we give up what marriage really means.
Well, Steve, thanks for coming on. We're going to talk more about marriage in general tomorrow on Faith and Freedom as we address DOMA, the Defense of Marriage Act. Folks, this is a big part of what Liberty Counsel is here to do, to defend life, to defend religious freedom, and to defend the institution of natural marriage. All three are inexorably linked, and Liberty Counsel is here standing in the gap in defense of freedom. Go to lc.org or give us a call, 1-800-671-1776. Learn how you can become a part of Liberty Counsel's ministry and help defend natural marriage. Go to lc.org.
You have been listening to Faith and Freedom with Liberty Counsel. We hope that we have motivated you to stand up for your faith, family, and freedom. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email updates. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.